Welcome back to Sunday Night in America. Our Constitution is majestically vague. To survive the ages, documents must have some elasticity. We know presidents have the power to pardon, command the military, faithfully execute the laws, and make appointments. But presidents have other powers not so clearly defined. This week's Supreme Court opinion was not about Donald Trump. It was about the power of the executive branch. It was about branch integrity, branch equilibrium. There are benefits to Trump, no doubt. The opinion rebuked special counsel Jack Smith's aggression, the D.C. trial court's failure to find facts, the D.C. Court of Appeals for its tautological conclusion. But Donald Trump is not the only living former president. This opinion concluded presidents are immune from criminal exposure for official acts. Presidents are not immune for clearly non-official acts. Those acts in the penumbra, in the periphery, in what John Roberts called the zone of twilight, require more fact-finding. Donald Trump may be in court between now and the election with hearings and arguments over what is an official act, but he will not be on trial. And truth be told, that's what has the left so apoplectic. They never minded a powerful president when Barack Obama said he had a pen and a phone and he would go it alone. They just mind when a Republican president is actually treated like an equal branch of government. Joining us now are former federal prosecutor Katie Cherkasky and former Manhattan prosecutor Elliot Felig. Welcome to you both. Elliot, Judge Juan Merchan postponed the July 11th sentencing so he could process how this decision impacts the New York case. In what ways might this opinion impact either the verdict or the sentencing?
I mean, ultimately, I don't think the motion to vacate based on the new Supreme Court decision is going to be successful. The lower court, the trial level court, is the place where you should hear the argument, though that's the only place where you can bring in new evidence and new arguments. You can't do that, of course, at the appellate level. So it did cause this delay, and the district attorney's office and the judge were right to consent to that delay because this is the place where the issue should be litigated. But ultimately, the question was similarly litigated unsuccessfully by the Trump team when they tried to remove this case to federal court back in 2023. So while I think the judge and the DA's office did the right thing by consenting to delay the sentencing, I don't ultimately think that the motion is going to be successful.
All right, Katie, let's listen to what are essentially public therapy sessions some on the left are engaged in, and then we'll talk about it on the other side.
If leaders can be immune from liability for criminal acts while in office, designed to overturn a free and fair election, that might very well be the end of our republic. This partisan Supreme Court just doesn't care.
I guess, theoretically, President Biden, acting within the scope of his official duties, could dispatch the military to take out the conservative justices on the court.
The president becomes a king in that circumstance, and it's just incomprehensible that the Supreme Court could come to such a judgment.
Dangerous precedent. Any president, including Donald Trump, will now be free to ignore the law.
You know, Katie, one has to wonder whether these Democrats have actually read the opinion, or if they read it, they just didn't understand it.
I would agree with that. I think that those sentiments are very myopic and very Trump-centric because the opinion in my perspective was very moderate and made a lot of logical sense. Once you start looking at hypotheticals in the realm of what a president can do and what they must do as part of their duties, there is endless ways to potentially criminalize that conduct if there's not some significant immunity for those decisions. It's the only thing that really makes sense in terms of how the executive needs to wield their power. And of course, the other branches of government are still there to put checks on that power and ultimately hold them accountable, especially if there's something that is unofficial. They can still be prosecuted. So I think that's very hyperbolic sentiments and not consistent with what the opinion actually says.
All right, Elliot, let's keep with that theme and listen to Joe Biden's interpretation of the opinion from his exclusive interview with ABC News anchor George Stephanopoulos.
The decision recently made by the Supreme Court on immunity, the next president of the United States, it's not just about whether he or she knows what they're doing. It's about the character of the president. The character of the president is going to determine whether or not this Constitution is employed.
You know, that's actually a false dichotomy. People don't have to pick between cognition and character. You can actually like have both. Nevertheless, to me, part of Jack Smith's D.C. case is dead. Part has a very faint pulse, and part of it may be very much alive depending on what happens in the hearings below. How do you see that D.C. case playing out?
Right. Well, because of the decision, every piece of evidence now has to be reevaluated. Let's remember, it took DOJ 2 years to bring this case. And just to give one important example, one of the key pieces of evidence in the Smith indictment, I thought, was this alleged conversation where Trump said to Mike Pence, to Vice President Mike Pence, the problem here is that you're too honest. I thought that was going to be a key piece of evidence, and Mike Pence would be a very difficult witness for the defense to impeach. But now that conversation is subject to a presumption of immunity, so a jury may never actually hear about that conversation. That's just one example. All of the evidence now has to be reevaluated.
Katie, the Chief Justice said the motive of a president is not relevant. So, in your judgment, how does this opinion impact what is called the fake elector portion of the pending charges?
Well, it's very significant that the lower courts, the trial courts, essentially are not able to use evidence of the president's motive in terms of determining whether an act was official or unofficial. So in terms of the president's authority to oversee the electoral processes, to essentially see the execution of the laws nationally, that is something that is going to take a very significant burden to overcome to show that it is unofficial if they want to use any of that evidence in any of these trials. And I don't think that they're really going to get there. And the other piece of the unofficial versus official determination is that if a trial court determines that something is unofficial, I believe that that is an issue that is immediately appealable up through the appellate courts again pre-trial, because it is such a fundamental issue before somebody goes to trial. If they're potentially immune, that has to be reviewed on appeal. So these cases are a very long way from trial if they even find unofficial conduct that can be prosecuted or used as evidence.
You know, we're all three former prosecutors. I found the motive part fascinating. You never have to prove motive, but sometimes it helps, and sometimes the jury wants to hear it. And John Roberts says, no go. Thank you both for joining us on a Sunday night. I have a sneaking suspicion this will not be the last time the three of us get together.
Thanks, you.
Trey.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.